Do you agree that there are some aspects of Article II presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article II functions.
Well, you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States, can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically is the risk that, and going forward, the risk. So you can take all of that.
I think that the question about the risk is very serious. And obviously, it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
I would assume that's personal. So,
well, I think that
that's what Brewster said.
Bribery statute in 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity or you can call it they can't do it, but what's the difference?
We call it an as-applied Article II challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. And it, in fact, delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president?
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain
Why?
the framework of why I don't think that that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
Well, I thought you
pattern.
said it, that was my question.
Yes,
and
I
you said
understand.
it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's
So
a
they
separate
couldn't-
category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article
No,
2.
he could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to
Assume he
violate it.
does. Corrupt,
Okay.
Nobody knows what corrupt intent means. We've been around that tree
We will
twice already.
probably find out.
And maybe it means that he knows that he was doing wrong, is what the
Perhaps.
government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from
Well,
going
let me
vote.
get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly gets legal advice from the attorney general on the lawful scope of the president's activities. And we could go down two tracks here. One is that the attorney general advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it
got it.
because you don't have to do that, and I would advise you not to
And
violate
then,
the
and then he
criminal
could be
law.
prosecuted.
No.
No, if he gets a negative opinion from the attorney general, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
Well, but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law.
And your answer-
And our answer is yes, he is subject to the criminal law.
Mr.
but-
Dreeben, can we go back to the bribery statute? I, like you, understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That is correct. And it's an extremely...
Official building. It's a very limited
Yes.
mention of the
And it
president.
really, I think,
So, as I understand this, there's two very limited provisions mentioning the president as included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the
Now,
fence,
Justice
Sotomayor.
Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think...
That's a tautology you can't escape.
Just Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly, that's the point, which
Exactly.
is if he's not covered by the criminal law, he can't be impeached for it,
Yes.
for violating it. All right. Now, could we go further on this clear statement rule? the situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was analyze what powers were being given to in the lawsuit and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept a bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context-specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, this is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right. Could I go back to your brief? And going back to what some of my colleagues have asked you, there appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
that is
correct?
Right.
You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that have to do with the president and law is that he shall take care that the law be faithfully executed, correct?
That is right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.